And we will be recording this training.
Sorry.
Thank you, Genesee.
And Beth, just a quick we are co-sponsoring this event with the Community Cares Committee of the Bronx Bar Association and our partners at Kingsbridge Heights Community Center, and we're grateful to be partnering for this event.
Thank you so much. Okay, so let's get started. We're going to share a brief introduction to POTS. Hopefully many of you who are part of this workshop are already familiar with the services that we offer, but we do like to remind folks who might not know about all the services that we have of our mission, our vision, and our values. And just to state the mission is to be a loving community in the Bronx that nourishes the basic needs and hungers of all who come to our doors. And you'll see that put into practice in all the services that we're able to offer. So our services are congregated in a few different areas, what we refer to as dignity and wellness services, food security services, and long-term stability. So our dignity and wellness services include our showers program, haircuts, our medical care clinic, which provides health and dental services on site, and a mail program where people who don't have a secure address are able to receive their mail at our location. Our food security program includes our pantry, our community dining room, and also the support that our case managers are able to provide in accessing SNAP benefits. And our long-term stability program includes our case management services, our social work services, financial empowerment clinic, our mentoring program that's through our long-term stability team as well, and also the legal clinic, which encompasses a range of services largely in the housing and benefits area. So some quick introductions. My name is Beth Maris. I'm the supervising attorney here at POTS, and I'm going to let Maeve introduce herself.
Hi, good evening, everyone. I'm Maeve Callaghy. I am a staff attorney here at POTS and happy to be joining with you this evening. Thank you for coming.
Thank you.
Genesee, can you introduce yourself, please?
Sure. Hi, everyone. My name is Genesee Alonso, and I'm a legal advocate here at POTS.
Thank you. And the other members of the legal team are doing a simultaneous presentation in Spanish. So we're really, really grateful to be able to offer this presentation in both languages. And thank you again for joining us. So let's get into it. We're going to start with just a brief introduction to Housing Court. And some of you may recognize the building shown in the picture, located at 1118 Grand Concourse, roughly 166th Street in the Grand Concourse. This is a building which has gone through quite a transformation in its operations over the last 2 years. It is currently open for limited in-person operations. There are some cases that are being held in person. There are services that are available in person. And there are also opportunities to access some of those services without coming in person. If you do choose to come in person, you should not be denied access. There is a health screening when you come in, and there is a security checkpoint that you go through. And there may be some attempts to limit the volume of people entering the building. But if you, for example, have a notice that you're supposed to participate in a court proceeding virtually, so by phone or video, and you do not know or do not have confidence that you can do so, you do have the right to come in person. So we just want everyone to know the building is open and available. There is another building at 851 Grand Concourse, which is near Yankee Stadium at 161st Street. There are 3 housing court parts that are located there, which are for trials, and there's also a part for New York City Housing Authority public housing cases. So those parts are also open. Just a reminder that the housing authority cases are not operating in the same way. They have discontinued a huge number of cases. Most of the cases that we saw in the calendar were cases where tenants were suing the housing authority for repairs. There are very few eviction cases, so they have discontinued a huge number of cases, and it's our understanding that they're trying their best to work with those tenants that may be in arrears or have other issues to try to resolve them without resorting to court. But again, that may change. We don't know exactly when, but there is a very, very reduced volume of housing authority cases at this time. This is a picture taken in one of the news articles of one of the Brooklyn housing court parts. So you can see, if you have experience with court in the past, you may remember a room that is very, very crowded, not enough seats, standing room only in the hallways. It looks very different today. So most courtrooms are practicing, they're limiting the volume of cases on their calendar, and they are practicing social distancing. And there will not be a huge number of people. If you do choose to come in person, you'll see a much reduced flow of people. What you will see also is the addition of video monitors, which are being used to conduct video conferences, and a reduced number of staff, as well as a reduced number of other visitors in the court. And the reason we've included the icon for Microsoft Teams is that is the platform that the court uses to engage in video conferencing for those that have that ability. We have the next slide, thank you. And we do want to just pause and acknowledge that there has been a tremendous amount of hardship that our community has experienced throughout this pandemic. Before the pandemic began, our community was already struggling with having sufficient income to meet the rent and with meeting other essential needs. The pandemic has made things much harder. There has been tremendous loss of life. There's been tremendous threats and risks to people's health and to those of their family members and loved ones. And income stability has been greatly disrupted by the pandemic and continues to be disrupted by the pandemic. So many things have happened during the pandemic to try to meet those conditions, but it frankly is not sufficient to meet the entirety of the need. And we just want to continue to remind ourselves and our community that we're still in crisis. We still have a lot to recover from, and it may take a very, very long to recover fully. These are, again, a reminder that there are many services that are available to help those who are at risk of eviction or who have the need to access housing court services. Housing Court Answers has been a tremendous support to everyone really through the pandemic, to the court system, to unrepresented litigants, and to others who rely on the courts. They're the folks that staff the information tables that are in court, and they are in Bronx Housing Court at this time at those tables on the first floor near the elevators in the Bronx Housing Court building. They also have a hotline where they answer questions during business hours. They're able to connect people who need arrears to available sources of funds. And they're also able to help with accessing an attorney if someone is eligible for an attorney, to try to make that connection. The Right to Counsel Coalition, this is a reminder that prior to the pandemic, there was a program called Right to Counsel, which was slowly rolling out through various zip codes. Access to legal services for free to tenants who were eligible for those services. And most tenants that are facing eviction are financially eligible for those services. During the pandemic, that expanded such that every zip code is eligible, and every tenant, regardless of where they live in the city, has the right to ask for an attorney to be appointed to them. So that is a change during the pandemic, which we're very, very happy has happened. And HRA is also open and available. So again, they're open in a slightly different way. They're not currently in person in court as they used to be on the second floor, but they are available by phone. The centers are open. They are encouraging people to access their services virtually. and through Access HRA to the extent possible, but they are open and they are operating. So just a reminder that even though things look different, the same groups that have been there to support tenants that are in crisis are continue to offer their services. There may be it may be challenging to figure out how to access those services, but they are there, they are operating, and they're trying to meet as much of the need as they possibly can. One of the services that's offered in the Bronx is what's called a help center, and this is currently available by phone or in person. It's located in room 250 on the second floor. And this is a center where if you have questions and you need legal information, there are staff that are available to help direct you. Homebase is another program that's very, very important to support tenants who are at risk of eviction. There are 3 home-based providers in the Bronx. Those are divided by geographic area. So that is BronxWorks, Help USA, and Catholic Charities. And if you believe you're at risk of eviction, you should consider reaching out to Homebase. You can call 311 to find out the office that's the one that's zoned for your neighborhood. It goes by the residential area where you reside. Okay, just a reminder again, there's a lot of support out there. It's hard, it can be hard to figure out who to turn to, but there's a lot of help, and we want to encourage everyone to make use of the supports that are there, because things have gotten more complicated with the pandemic, and there's a lot of protections that are out there, but it's very, very important to be connected to an advocate if at all possible. So we're going to go into a couple tips and hopefully help in identifying some resources that you may need. So number one, this is one of the hardest questions I have found during the pandemic, is to try to determine if someone that is seeking our services is, quote, in court, because things are not happening in the same way. So if you look at this, the image that's here and the banner across the top, that is a court paper which has been stamped through a system called NICEF, the New York State Court Electronic Filing System. So it will have an index number, it will have a document number, it will have a title. And we're going to show you in a moment how to look in NICEF to see if there's a case in which you might be a party. So the way to know if you're in court is if you received a document called a petition, which is typically the document that is served and filed to start an eviction case. If you receive a letter that had a date and a time to come to court, that's another reason that you might understand that you have a case in court. What can be really confusing is that it's possible that a case was started, and it used to be that those cases were calendared immediately, but there have been very long time lags in many cases. So let's say someone got a petition that's dated in September 2020. Perhaps it wasn't scheduled for court for months and months, or even more than a year. And so it's hard to know when your case is active and when you need to respond to it. So these are some tips that we're going to show you, some tips about how to identify whether or not there's a case that's actively in court. So again, NICEF refers to a system for electronic filing of cases. This was completely new for housing court. It was started during the pandemic. It was available for other courts, but not for housing court before the pandemic. And as we highlighted, you search it as a, quote, guest, and you can do a name search, you can do an index search to try to find out if a case exists. But if a case was brought through electronic filing, it should appear on NICEF. And many cases that were brought before electronic filing may also appear on NICEF. And that would be, let's say there's a case that was started before the pandemic, but it didn't resolve before the pandemic. It's possible that it can be converted and added into NICEF. And so you'll be able to see it even though it started prior to March 2020. So we're showing two screens here about how you could do a search in NICEF. You could check by what's called the case identifier, which would be an index number or a docket number. And we've highlighted where you would enter that information. You can also search by name. And you can search by a business name. You can also search by an individual name. I have not had very much luck if something is misspelled. And so you may have to spell it exactly, but if you are looking for a case and you don't find it, you think it exists, you could try a couple different spellings, or you can try to get the index number, or you can call the clerk's office if you need more help on identifying a case. The other, this is another source that you can check if you're trying to check if there's an active housing court case. This is called Web Civil, and the website is there on the side. And again, you can search by index number, you can search by name. A case will only appear on Web Civil if it has a future court date. So just because it's not found here doesn't mean the case is not an active case. It simply means there's no current court date. So a case could have been filed and then taken off calendar for a range of reasons, but this is another way to check to see if there is a court date or an active case in housing court. And these are the search windows. If you were to check on Web Civil for an index number for a case or for a name, and you can help yourself when you're searching by limiting it to Bronx County, for example. Case type would be LT for landlord tenant. And if there is a case, if the case has a future court date, it should appear when you do that search. So just because someone, sorry, let me restate that. Whether or not you're in court, you may still have, for example, rent arrears, but we do try to determine if somebody has rent arrears and is being faced with possible eviction. So landlords are required to send a 5-day notice if someone is late with the rent first. They're also required to send a written 14-day rent demand detailing the amount of rent that's owed and stating a date by which it must be paid. And only after that date has passed can they start a non-payment case. So those are what we call pre-court notices. There's also pre-court notices for some holdover cases, which are a different category of eviction case. If you want to know if something is active in court, you would want to confirm that there's a petition and a notice of petition that was generated, that piece of paper was served and is filed. It's also possible that no recent petition was filed, but the case may have been filed before the pandemic, before March 2020. It would also be an active case if there's a court date that's scheduled or if there's a marshal's notice of eviction. And we are seeing marshal notices again, unfortunately. So that is a possibility in cases today. This is an example of what some of those papers look like. So a petition is on the left, a notice of petition is on the right. The notice of petition has general language that will tell the person who's receiving the papers some general rules that the court is going to follow and deadlines that should be followed. Again, during the pandemic, this was quite confusing because the notice of petition might say certain things had to happen within a time frame, and then it would come along with another paper that would say these timeframes may not apply to you because of the pandemic. At this point, those timeframes do apply. So if you receive a petition and a notice of petition, you should answer it if it's a non-payment case and reply to those papers. If it's a holdover, those papers will set a court date and you should appear or participate on the court date that's set for those papers. This is an example of some papers that are not yet court papers. So these are a 5-day notice and a 14-day notice. They look a little bit different and they wouldn't have the banner at the top that indicates that it was filed through NICEF unless it was part of something else. So you might see a 14-day notice with that banner, but that would only be if it was filed together with a petition, for example. They can't file those pre-court notices without starting the case first. And this is an example of a court date notice. So there's a lot of information on this letter. And it's really very important to not misplace these letters because they will tell you how you can join the individual case that you have at the right time. One thing that's very, very different since before the pandemic is that case times are much more specific than they used to be. It used to be that many, many cases were on for the same time, let's say for 9:30. And if you came at 9:30, you might wait and nothing might happen for hours at times. In the current scenario, that doesn't happen. And so if you have a court appearance for 9:30 or 9:45, you will have missed it if you don't appear at 9:30 or 9:45, meaning you could have lost your opportunity to participate in the case. So those cases are typically on for much shorter timeframes. And because a lot of things are done virtually, the court has already moved on to other cases after that window period for the time for the case. So it's really very important to participate. And just a reminder that this letter will say various ways that you can participate. One is by Microsoft Teams. You can also call in by phone. You can also appear in person. If you appear in person and the courtroom is not open, you can participate through a video conference that will be set up for you in the courthouse itself. And if you lose the notice or you have any questions, the general number for the clerk is here, which is 718-466-3000, and you should feel free to call if you do have questions. Okay, I believe at this point I'm going to be transitioning the presentation over to my colleague, Maeve Callaghy. Thank you, Maeve.
You're welcome. Thank you, Beth, for giving us a great start here. So we're going to go into more specifics on what to do when you get a petition, which, as we said before, is what actually starts a housing court case. So in general, and this applies right here, we suggest that you read the entire document carefully. So that means looking at who they're saying the tenant is. If they're saying there's someone else living with you, there's a roommate, if there's somebody you don't recognize listed there, look at the amount of the rent that they're saying is owed. Does it look right to you? Have you paid those months that they're saying you owe? Just things like that to get yourself familiar with the landlord's claims and will help you going forward in the case. Aside from that, we are always recommending that people get legal help if they can, either through an assigned lawyer or calling organizations. And even if you can't get legal help immediately, you should answer the petition on your own within 10 days of getting it. So basically when you're answering it, it is something where you get to address everything the landlord is claiming about you and your tenancy, and you get to put in your own defenses as well. So you should call the clerk's office and give them the index number to answer by phone, or you can go to the window on the first floor of housing court, and you would tell the clerk the defenses you have had, including if you had a financial hardship during the pandemic, such as losing your job or losing hours at work, and also if you have applied for ERAP, and then give your application number and date of birth to the clerk so it can be noted on the answer, because as we'll get to, having an ERAP application that's still active can give you extra time to resolve your case. So this is a sample answer. And I think some of the forms are a little bit different now, like they were updated to include 13 and 14, which like is specifically related to COVID and kind of this post-pandemic world. But basically here you would address the different things like, did you get the papers, right? Were they left kind of stuck in the apartment building door? Were they shoved under your door? Did you get them certified mail? Then do you owe the rent that they're saying you owe? Do you owe some of it? Do you owe none of it? And just make sure that you put down everything that applies to you, even if there are bad conditions in your apartment that are in need of repair. Some people think that because they owe rent, they can't bring up their own claims, such as there's mold, there's a chronic leak from the ceiling. Things like that are important to put in the answer as well. Okay, so how can you participate in court once the case is going? You would read the court notices very carefully for instructions, because there can be overwhelming amounts of, paragraphs of information, but it's important to see all your options for participating. Definitely, if you can, look up the case online to confirm the date and time. And if you have to be in court, or you could do it virtually or over the phone, then of course you can always call the court for any questions. And finally, these are the three options, right? Appear on video, appear by phone, or appear in person. Okay, and here we're showing this to you again, which I think is worth it because it is kind of it's almost hidden in here that there's an extra option. If you can't appear virtually or over the phone, you can appear in person. But then at where the information is blacked out, those are like the links, the conference ID numbers, and different identifying information for your particular case. And it is really helpful if you keep that in your possession, so you can be sure that you have that information with you. Okay, the big one. What if I missed my court date? You would call the housing court clerk as soon as possible with your index number. Sometimes missing a court date happens after you've answered, or sometimes it happens before you've answered and it was set like on the calendar, but you hadn't put an answer in yet. So if you haven't done an answer, you haven't actually responded to the petition yet, and even if the 10 days is already passed, you should immediately file an answer. And when you speak to the court clerk, you would ask what happened on the day you weren't there and what steps you should do next. You should definitely go to court to submit an order to show cause. That's something that some of you may be familiar with that term, and you would explain why you missed the court date. Maybe you didn't know about it, like you didn't get the notice from the court, or you were sick that day, or you couldn't figure out how to participate virtually. I know I had a client recently who was sitting by her phone at the time that she was supposed to be appearing virtually, but she thought the court was going to call her. And so she unknowingly missed her court date, and it really wasn't her fault, not intentional. So you would explain those things, and also your defenses to the case, such as, there were repairs, there's an incorrect rent amount they're claiming, things like that. Okay, and then what should I do if I receive a marshal's notice of eviction? I know that people in general, or many times, will say that any kind of document or indication that they're behind in rent or they have to go to court is a notice of eviction, but this is actually a notice of eviction. So this is the only notice that means you can actually be evicted. And this requires immediate action. So you should call your lawyer if you have one. And if not, you should go to court to file an order to show cause. Again, that's the same thing we had talked about. If you miss your court date, in this situation too, you would file an order to show cause and then try to get an attorney. And either way, whether you end up getting an attorney or not, you should participate in court as like the process goes forward. So I just want to make it clear that this is what a tenant has to get before they can get evicted. So like a letter from your landlord saying that you owe rent, or a petition, those are not notices of eviction. And here at the bottom, you'll see dates that show the date of the notice and the first possible date of eviction. And if you receive a marshal's notice, we are recommending basically at every step that you try to get an attorney. And that's kind of why it's being repeated a bit, because it is so helpful. Because the vast majority of landlords have lawyers and the vast majority of tenants don't. So we always encourage you to access at least legal assistance if you can. Yeah. Okay, and here we've summed up the top tips that we have for tenants. So do ask for help. Do apply for ERAP and other rent arrears assistance. These are resources that are available to be applied for. And we suggest that everyone apply, even if you have doubts about whether or not you'll actually get it or get approved. Do get a free lawyer if you can. It may not be immediate that you're assigned an attorney, but it's worth the referral process. It's worth the wait to get some real legal representation, and do participate in court. Very little that's good will happen from ignoring court notices or deciding not to go, or letting your nerves get the best of you. So definitely participate in court. And the big don'ts: do not ignore court or legal notices. They will not go away. And I think we've all had experiences with that in our own lives in different areas, but this is a very severe one. If you ignore these notices and letters, it doesn't go well. Don't miss a court date. And if you do, please go immediately to do that order to show cause that we talked about. And finally, do not move out of your apartment without getting legal advice. So I know we're hammering this home here, but owing rent does not take away your right to stay in your apartment, right? And your landlord being angry at you does not take away your rights as a tenant. And many people in the Bronx and the city and the country are struggling to pay their rent. But if you move out, it can actually be worse for you and your family, and you may be giving up the rights that you do have right now. So these are the COVID-19 protections for tenants. These aren't the only two, but we just want to highlight that tenants with a pending ERAP application are protected from eviction. So I think we've spoken about this. I don't know if we've given the full name, the Emergency Rental Assistance Program from the state. If you have a pending application, meaning that your application has been submitted, but it hasn't been decided yet, you would give the court clerk, the court attorney, some kind of indication of your application number, whether it's a printout or just telling them what it is. And they would put that in your case file, and it would likely be marked off calendar until the decision is made. And then if a tenant had a financial hardship during the pandemic, you may be protected from eviction under the Tenant Safe Harbor Act. So there's also, many of you or people who are in housing court may have received the Hardship Declaration, and it's very broad and it covers many different situations and categories and ways that people may be struggling. So it's not just limited to losing your job. It could be that you had to take cabs because you have an underlying condition and you were unable to take the bus safely. So things like that can, sorry, I'm seeing chats pop up. Good questions. But yes, so that may be something that you can assert as a defense to being evicted. And then more protections for tenants. Tenants have the right to request free legal representation in housing courts in housing cases. And we do have how to access those resources at the end of the presentation. One of the biggest things to remember is that landlords and owners may not evict tenants on their own. And a tenant can only be evicted by a marshal only after the eviction has been approved by the court and a marshal's notice has been served. Right, and even then you still can file your order to show cause, ask for more time. It's not a done deal. So how can I get legal help? Here you would call 311 and ask the tenant helpline to get free legal guidance. Call for a free lawyer through Right to Counsel at this number. You can email civil justice, call housing court answers, or ask for a referral from the judge if you're like there for your court date and you say that you want a free lawyer. And for more immediate legal advice and help, you would call the first two, the tenant, oh, sorry, no, you would call the tenant hotline or housing court answers for more immediate help. But the other ones are useful as well to get an attorney. It just may not happen that day to get an answer if you have a question on your case. So here we go into resources. Right, so there's really good information actually on the New York City website right now. This is all going to be included in the slides that we send out, but the tenant resource portal is really helpful, as well as the New York State Court website. And things do change pretty regularly as things are kind of getting, more relaxed, and then we put our masks on again. So it's really helpful to stay up to date by checking the websites and calling the clerks. And here is for checking your ERAP status online. Again, this is the application for rental arrears assistance, and all you need is your application number. It's kind of a misnomer. It's not really a number so much as a combination of letters and numbers, or sometimes just letters. But you would put that code in the application number and then put your date of birth or whoever's name. Like, you need the date of birth for the person whose name is on the application, right? So like if your wife actually did the application, it would be her date of birth. And yeah, it's really helpful to check. And you can see if there's some kind of holdup, if it's been approved. And if you need more information, you can definitely call the hotline down there, the 1-844 number. And I've found them to be helpful, and the waits are not that long anymore. If you're calling about ERAP. And this is for new applications. This is their kind of portal screen. You do not need to make an account to actually do an application, but it can be helpful to log in and see more kind of information about what you've done so far. And it's not clear. I know that there's a lot of kind of rumors or what have you about whether there's money there for ERAP applications to be approved, whether you can get ERAP at all if you have Section 8 or another subsidy. And really what we recommend is just apply. Nothing bad. I don't think it's anything bad could happen from applying and trying to access these resources. You may not be eligible, but it could be a benefit if you are in housing court, and it will give you like time to be put off the court calendar if you have a pending ERAP application, even if ultimately you may not get the funds. Yeah, that's it for that. And so this is for specifically ERAP applications. You can contact NICA. They're another organization around here in the Bronx, and Bronx Works. And yeah, they have phone numbers and email addresses there. And just in general, these are places where you could get some assistance for HRA, whether you want to apply for benefits, apply for a one-shot deal, just food stamps, anything like that. You can apply through this link in the app, Access HRA, Homebase. You could, like we said before, on the map, sometimes it could be hard to determine which one you belong to. So call 311 to see which home base you should go to. Also Housing Court Answers, different charities and nonprofits, like Catholic charities, things like that. Then Homes and Community Renewal. That used to be called DHCR. And it's for people who are in buildings that have 6 or more units. So like regular big buildings. And you can get information about the rent, like the rents that they were charging to people before you for rent stabilized apartments. And you can try to determine if your rent is legal or if you're being overcharged, things like that. And then Section 8, for those of you who have Section 8 vouchers, there can be a lot of issues with recertifying right now. People were told all different things. They didn't have to worry about it this year. Oh, you should come into the office. Oh, the office is closed. Anyway, so getting information about Section 8 could be very helpful for you. And this is our information about the POTS legal clinic. It's our office number, extension 101, or that's the email address, like just for our legal clinic, our legal team. And yeah, just to wrap it up, please contact us. Remember all the different services that we can offer to the community. We do call ourselves a one-stop shop for our area, and we welcome you to come in, even if it's just for lunch. So, yeah.
Maeve. I feel like we should all stand up and stretch, but we will start trying to answer some questions. Just wondering if we should take the presentation down for a moment, and so we can, I want to invite people to ask questions in the chat. If you prefer to raise your hand and ask your question verbally, that's also completely fine. We did have some questions while the presentation was going, and we got some questions in advance of the training, so we're going to do our best to address those. Pull up the chat, and I think Genesee was going to help us with these questions once we're ready. So let me just pull up the chat at the same time.
Yes. So, sorry. So Marlene asked, how can you find a free of charge lawyer if you don't have the finances to pay for one?
So the resources that I was kind of listing and speaking about, those are all free lawyers. So different organizations are part of Right to Counsel, like Legal Aid, Legal Services, Bronx Defenders, things like that. And those organizations or the judge can give you a referral to a free lawyer from one of those places. So definitely use the resources that we'll send to you in the slides. And that's the best way to go. But yeah, you do not have to pay for a lawyer to represent you in court.
I just want to add a little bit more information on the attorneys. It's been really hard to know how to access attorneys, because even though they're available, it's hard to see sometimes how they're getting assigned. And some people who have housing court papers but don't have a court date yet may find themselves unable to access lawyers in that moment. But when you first get your first court date in what's called an intake part, there should be an attorney standing by either virtually or in person who's there to connect with you to potentially assist you with your case. So that is one of the best ways. Hopefully the timing works and you are able to access attorneys through that in that method. But if not, any of the other methods that we outlined would be helpful.
Ms. Wilkinson, it's not really a question, but she feels there seems like there's no help if you have a housing voucher.
It definitely can feel like that. And I think that's, I guess, what I had touched upon before. When I've heard many people tell me that they were specifically told they can't get assistance from ERAP because they have a housing voucher. As far as I know, that's never been an actual policy, but I do know that there was a priority for people who were paying, who didn't have subsidized rent, right? However, there are many charities that have money to help out with rent arrears. One-shot deals are still available to people through HRA. And I wouldn't be discouraged, but I don't blame you for being frustrated. But yeah, we have, I don't know if we have specific things about other like places to get funds, but the list of things that we had said, including charities, home base, and access HRA, those are things that are definitely open to all applicants. Yeah.
I just want, again, add one little thing, which is HRA at the beginning was not processing one-shot deals for anybody who applied for ERAP. That should no longer be the case because HRA understands that people who haven't yet been approved are less likely to be approved. And so someone who's subsidized to apply for ERAP whose application is still on hold, I think does have a greater chance at this time of getting assistance through HRA as well as other avenues if their ERAP doesn't get processed.
Next question, what about if you had an ERAP application and it's closed? Can this still help or not? Or would you recommend applying again for rent assistance?
And I'm sure many of you here have had more than a few clients in this situation. If so, I think you're asking if you had an ERAP approval in the past, but you're still behind in rent now. I would definitely recommend applying again for rental assistance, either from ERAP again, if you didn't get the full 12 months of rent arrears from them, or just from, you know, one-shot deal or other charities. If what you're saying is your ERAP was denied, I would recommend applying again. If you don't have a pending ERAP right now, then no, you won't get that benefit of the court case being put on hold. But if you didn't get the full 12 months of ERAP before with your first application, maybe you got a 6-month like of arrears approved, right? And now you're in court. If you apply for ERAP again, you will get your case put on the side because you can get the other 6 months of assistance possibly. So yeah, this was very unclear, but I would say yes, you can apply twice for ERAP and you'd need an active ERAP application to have it put like off the court calendar and put on hold.
Next question, what happens if I'm subleasing, but I don't have a written contract and the actual tenant is not paying rent?
I mean, there's a lot to say there. What happens? I mean, in terms of legal responsibility, I guess I would be, this is something where I would prefer to speak afterwards in a personal situation that does have a number of factors in it. So I think we're going to give you information on how to contact us directly, but I do think that this is an important issue that comes up a surprising amount. So if you don't mind, sending us a message later on, that would be great.
Sure, I can also make a note of the attendant's name so that we can reach out to her later.
Okay, sounds good.
We have a Dundon with his hand raised. I don't know if he wants to type in the chat, or you can unmute yourself and feel free to ask your question. Maybe he'll come back. There is another question here. Can you still apply for rental assistance if you are in a low income housing apartment?
Do you want to go? I can go.
Sure. I'm sorry, can you repeat the question? Just to make sure I caught.
Sure. Can you still apply for rental assistance if you are in a low income housing apartment?
Yes, so as Maeve was touching on already, you can apply for ERAP or for assistance through HRA or from charities if you're behind in the rent. ERAP has a priority that is for non-subsidized tenants and by statute. So if you have a subsidy, you will not receive priority for ERAP and you may not be approved. But you have the right to apply for ERAP. You're eligible as long as you're a tenant and you had a financial hardship and you are otherwise eligible, and you're also eligible for other assistance from the sources that we mentioned.
Just wanted to share in the chat, our colleague Juan also shared a link where you can request a rent history and also request repairs at justfixit.nyc. And we do have another question from Emma. What happens if the landlord doesn't sign a new lease 2021, but sends one a year later for 2022.
Beth and I have recently come across this with one of my clients for sure. It's a little bit like confounding, frustrating, because it feels like something's missing, something's wrong, but you can sign the lease from 2022. And I don't know, Beth and I had kind of spoken about this and like playing out different situations of like what would happen or what would be different if you made them send one at the right time or what have you. But if they were charging you the same amount of rent the whole time, and now they're giving you a renewal, I mean, maybe I shouldn't say this without hearing what Beth has to say, but I feel like it's in your best interest to have a lease like renewal signed, because they can sue you for failing to sign a renewal lease in a holdover. So that's also something to keep in mind when thinking about it.
So the person who asked the question is putting in a clarification. I just want to say that there might be a different answer if this is a rent stabilized apartment as opposed to another type of apartment. So those of us that follow the news probably saw that there are increases, more higher increases that were authorized by the rent guidelines board. Those are for leases that take effect starting on October 2022. So I think the scenario that Maeve and I were discussing was someone didn't get a renewal lease timely. However, if they demanded a renewal lease now, the rent may go up to a higher amount than if they did it earlier. So each situation is going to be different. It's going to be very specific to your circumstances and the type of housing. I am again looking in the chat. So the person who's asking the question says they signed a lease and emailed it to the landlord, and then they offered another lease. So that's I think you want to review your exact situation with an advocate or an attorney, because if you signed a lease and they're offering you a lease sooner when you already have a lease in effect, then you wouldn't want to sign the next lease. You would want them to honor the original lease. But we sometimes see situations where perhaps it's not clear what term is covered by a lease. So with rent stabilized lease renewals, you know, it offers the tenant an option to choose a 1-year term or a 2-year term. Sometimes tenants will sign it, but they won't mark which term they want. And so it could be confusing to just know exactly what time period is covered by that lease, or perhaps the landlord makes a change to it after the tenant signs it. There's different scenarios. So I think it makes sense to review the specific leases you're talking about with either an advocate, an attorney, or you can also go to HCR. You have to request an appointment. You can make appointments to meet with a counselor there to review what the paperwork shows.
I see Denton is unmuted if he wants to ask this question.
Yes, I wanted to ask a question. Can you hear me?
Mm-hmm.
Yes, go ahead. Thank you.
Yes. I actually applied to ERAP and got approved, and we approached the landlord about it, and she doesn't want to do it. So what next? And guess what? She also put, when we went to her, she also put $200 extra on the rent that is already high. So I really don't know what to do.
Could you tell us what type of housing you're in? Are you in a private house or are you rent stabilized?
It is a private house. No, I'm not on anything. I'm not on
Okay,
anything.
made you.
Sure. So I know there are unfortunately some situations like that where tenants get approved, or they start the process and their landlord doesn't want to cooperate with them.
Right.
It is possible, as you now know, to get approved even without your landlord doing what they're supposed to do to kind of finish the application and claim the money and those things. So basically what happens now is that since you're like fully approved, then the state puts aside the money that was approved for the landlord for the next 180 days, like 6 months. And if they don't pick it up in that time, then basically it gets put back in the pot of money, I suppose, for ERAP. But the thing that really happens with that is if your landlord then brings you to court, right, and tries to sue you for rent that they could have had paid
Right.
from the ERAP money, then you could bring that up in court and say, Your Honor, they could have had this money 6 months ago and they refused to comply and pick it up. And that could be a defense to a housing court case for that period of time that the ERAP approval was for. And unfortunately, as for the lease renewal and the increase of $200 in unregulated housing, it's very much up to the landlord how much they want to charge for rent. And that is unfortunate because I know a lot of people are in unregulated housing, like private houses or smaller buildings, and it's very difficult when they want to raise the rent on you. I don't know if you have anything else, Beth.
Yeah, just to say that you don't have to agree. So a lease is a contract, meaning it's an agreement between two parties. So at least two parties. So if the landlord says they want to raise the rent by $200 and you don't feel that's appropriate and you're not able to pay it, you don't have to agree. However, if you don't agree, they would most likely take steps to recover the apartment. So they might force you out or try to force you out by bringing an eviction case. But you could try to negotiate with them to see if you can get them to come down. And if you don't agree, they can't compel you to pay the increase, but they can bring another type of a case to try to evict you from the apartment. Those cases take some time, and you might have, depending on how long you've lived there, you might have sufficient time to find other housing, to look for something while the landlord goes through that process.
I have been trying. I made an application to the Kingsbridge Garden apartments, and I'm waiting. I'm hoping that something will come through so that I can, either leave here because she's really not cooperating, and she doesn't even fix anything inside the house. And I've been here already 6 years.
6 years. Okay, so depending on my other question that I wanted to know, if you've been there for that amount of time, you would be entitled to a notice of at least 3 months before they started a holdover case against you. And if the holdover case was brought, you would be entitled potentially to up to a year to vacate. So that's discretionary with the judge, but you might have more time than you think if you really do want to leave. And again, it's expensive for landlords and also disruptive to have to replace tenants. And so it might be something that's worth trying to have another conversation with the landlord about, to say, I don't, if you do wish to stay, to try to negotiate for hopefully a reduction in that increase.
No, I don't think she's gonna even listen to that about the decrease, because in the area that I am in, I think she believes she can get more. Although she put $200 more on the rent, I think she believes she can get more. She's a cocky person who, she don't mind us probably leaving, so she can put the rent even up higher, because this particular area, it's close to Jacobi Hospital. She thinks she can get more for this apartment.
Well, just a reminder, you don't have to agree to anything that you feel
I
you
did
can't
not.
do and don't wish to do. Yeah.
My husband and I did not sign.
Okay. And if you do find yourself with other questions, you're more than welcome to reach out to us or to any other the offices that work with tenants.
Are you gonna post something online when you're done?
Yes. So our email is legalclinic@pottsbronx.org, and we will also share those contacts.
Okay, thanks.
After the training. Thank you for your question.
Bye-bye.
you. So I will be sending the legal clinic email in the chat. Another question, how much do you have to be behind in rent before you are served an eviction notice?
I guess I'm gonna go with, you're asking how much you have to be behind before you get a rent demand, which would be like the first thing you get with your landlord saying that you owe rent. And I would say, 1 month. I mean, there's no particular time they have to wait. It's not normal to sue people after 1 month. But anyway, if you're behind in rent, you can be sued in housing court. And then to be served an eviction notice, I mean, serving an eviction notice it doesn't depend on how much rent you owe. The marshal's notice happens at the end of a lot of steps in housing court. So after there's a judgment for a certain amount of money, for example, and then you fail to pay by some date, and then they applied for the warrant of eviction, and then you got the marshal's notice. That's just a series of steps. It doesn't depend on how much you owe. But maybe I'm not interpreting the question right. So that's what I think.
Yeah, let me just add that exactly what you said is absolutely correct. There's no amount that someone has to owe or not owe. And if there's any amount and the landlord brings a case and there's a judgment granted to the landlord, there is a possible eviction.
Thank you. Next question, what happens if you have an open ERAP application and your landlord is aware but still sends a legal notice to proceed with legal actions?
So I can take this one if you want. This does happen. So when a tenant applies for ERAP and you should notify your landlord, they're going to need the application number. They're also going to need your date of birth in order to confirm that you have a pending application. At that point, the landlord is not supposed to commence a proceeding. They're not supposed to move forward with an eviction case. If they do, and you learn about the case, you would then notify the court of your application number. If the landlord starts a case and then they learn that you have an ERAP, they're actually required to notify the court that there's a pending ERAP. That's in the law. So they're supposed to report it. If they fail to report it, you should report it. And if the court verifies that you have a pending application, they should put the case on hold while the ERAP is under consideration until that application is decided. So I guess the overall comment is don't trust that they're gonna do it. If you see they're not doing it, make sure you speak up and you report to the court that information on your own.
We have a hand raised. Marlene?
Yes, hi everyone. I just have a question based on what you were saying. That was actually my previous question. And I did, I had a situation with my landlord where I fell behind, and that happened when I lost my job. I'm currently working a couple of months ago, and I just lost it due to the pandemic. And what I did was I started making partial payments, and at the same time, like extra kind of payment to kind of balance out the previous rents that I owe him. So I asked him if there is any way possible for me to do some kind of like payment arrangement, which he said that he can do, but he still have to continue processing like legally. So I didn't quite understand that. I mean, he's giving me the opportunity to kind of become current, but you still wanted to proceed legally when you know that I had an ERAP case. So what happened with me with the ERAP is that they actually pay like half of 1 month and didn't pay the rest due that the landlord didn't send the documentation that they asked them for on time. So what they do is that, they actually close the case, to a specific documentation that they needed from the landlord, right? And what I'm trying to do is actually open up a new case. And again, by the time the case was still open, like 2 weeks before they closed the case, he knew and he said that he was aware that I had an open application in ERAP, but he spoke to his lawyer and he said that he can still proceed legally. It's like he's like saying, okay, it's not gonna be any problem. You can do a payment arrangement, but I'm still gonna continue with legal actions regardless. So like that's why I'm kind of confused.
Right. I mean, they shouldn't, if they know that you have an ERAP application, and I assume he has the information that, like, because he didn't provide the information, but he was aware of the application and your date of birth and all that stuff that was pending.
Right, because it was actually the assistant, the one that used to put in the information through the through my application using my data, all of that.
But it was approved, but only for a small amount of money. Is that correct?
Right, because she didn't send the current legend or the statement of rent that I owned in the past. She didn't actually submit it on time. So that's
Okay.
why.
So there's no pending ERAP right now. Is that right?
No, it's not.
Okay, so yeah, she can continue with the court case. I mean, at this point, and yes, I understand that, like, on a personal level, you made an agreement to make partial payments, but it sounds like the landlord wants to kind of, in case that doesn't come through, in case they don't get all the money from the partial payments, they still want to continue with the court case to have that option going. But if you only got a small amount of money from ERAP, I would suggest you reapply and disclose to the court immediately that you have applied again and this is your application number. And that should mark it off calendar if and when it, gets in front of a judge. I'm not sure what stage of the housing court process you're at now.
Yeah, so I don't think it's actually on the court as of yet, because what I was told is that he is actually proceeding with legal actions, and I'm gonna receive a notice soon from his lawyer, asking like for 14 days for him to get funds.
Gotcha.
So
Okay.
like what is the next step, and if that happens, that he sends me to the court, do I have like to get all the monies that I owe him? Can I like continue living in the apartment? Do I need to go, to get another place? Like, I just want to make sure, like, this is the first time that I actually go through a situation like this. So I just want to be kind of informed what to expect in this situation.
Yeah, so I mean, kind of the court process is they demand the rent. If you don't pay it by a certain date, they can continue by bringing you to court, and you would appear in court and make an agreement or go to trial. That's how the process goes. I understand it's like a very stressful thing, but you're not in court yet. There's no active case because you haven't even gotten the 14-day notice yet. Not to say there's not a situation and you're not headed that way, but I would just like repeat myself, like apply for ERAP right away. So that if and when you do get court papers, you can respond and give them your application number, and that will make it so it's not on the calendar, right? They just put it on hold over here while ERAP is making a decision. That's my suggestion, but Beth, please chime in here.
No, agree 100%. I'm sorry, go ahead.
Yes, what I was saying is that real quickly is that ERAP actually took about 6 months to respond me back with that response because they are behind. So I just want to know what to expect basically.
Yeah, I just want to agree with Maeve. You have the right to apply again if you didn't already get the maximum that you could apply for under the program. So the program authorizes up to 12 months of rent in arrears and up to 3 months of future rent if someone is rent burdened. And so if you got a small amount in your first application, even though it took 6 months for OTDA to decide it, you have every right to apply again and you would be entitled to a protection. And that might also give you time to get things together in a place that maybe you won't actually need the ERAP if you can figure out how to catch up. And you can also seek other assistance at the same time. And just simply filing the ERAP application and having an application number that the landlord can verify will or should stop the housing court case from proceeding.
And I'm sorry, I just wanted to chime in based on what you said at the beginning that you have returned to work recently. It sounds like if this is true that you have future ability to pay the rent, there are other options for finding some of this money from private charities and from HRA. And I think that was mentioned earlier. And so often the biggest obstacle to getting rent arrears assistance is that people don't have future ability. But if you are able to pay your rent going forward, this sounds like potentially it's a solvable case. So certainly don't move out. Just to reemphasize that, like this, if you want to stay in this apartment and it's affordable for you, this sounds like a case that could be resolved.
Okay, and I see a follow-up question in the chat, so I'm just going to try to address that question as well. The comment is, I was under the impression it was not possible to apply to ERAP a second time, and that there was a client that this person worked with that requested an appeal, but would an appeal provide legal protection? So I just want to break up that into two questions. I think it's very confusing to know exactly what's permitted with ERAP. So we're basing our answer off the statute, which says that you can apply for up to 12 months of assistance. We're also basing our answer off staff at OTDA. So as Maeve mentioned, there's an information number for OTDA for anyone who has questions about ERAP. It has been, how do I say this? We sometimes find that we don't get the same answer depending on the representative that we're speaking with. So we sometimes get inconsistent answers, but we have definitely been told by staff at OTDA that you can apply more than once, and people have been encouraged by staff at OTDA to apply for a second time. So my understanding is there's no bar to applying for a second time. If you got 12 months of arrears in your first application, I would personally not recommend that someone apply again because I don't think you would be found eligible. But if you did not get the full 12 months of arrears in your first application, I think you do have the right to apply again. And as Jack said, there's other ways to resolve arrears. So let's say someone was approved for ERAP, is in arrears again after the ERAP period, and has the ability to pay rent now. That's a perfect case for a one-shot deal application or for applications to a charity. And HRA should understand that even if there's a pending ERAP, if that ERAP was filed more recently, it has a lower chance of being approved, although we don't yet know how many applications will be approved. So HRA should consider that application. To answer the question about the appeal, so that one's a little trickier. So you're entitled to a stay if the ERAP application has not been determined. And I think if there's a pending appeal, you could certainly argue that the application has not been determined, even though it was decided and it's still under review. So I would feel very comfortable arguing that you're still entitled to a stay, but I think you have to make the argument and explain to the court and the landlord what's going on.
Yeah, I agree with that. I just had a case with a client today in court who has a pending appeal for her ERAP application that was just denied overall. They said she didn't hand in her documents when she did multiple times. And so it was denied. So I just told the landlord's attorney that it was still pending because it's on appeal, right? And that may not have been, I don't know. I don't know if he's going to agree with me, but in my mind, that is still pending because like the appeal hasn't been decided yet.
I want to switch gears for a moment if we can. I see a question about preferential rents, and I know we had a question in advance of the training about potential overcharges. So I'm going to try to tackle that question. So the question is, can we talk about preferential rents and being overcharged? So preferential rents is a reference to something that happens with rent stabilized housing. And again, rent stabilized housing is a particular type of housing in New York City that has protections against certain increases. You have the right to a renewal lease. You are supposed to be free of getting any illegal increases. And what happened over the years is that landlords would have let's say a market rent that they believed was legal, but that market rent was higher than people in the community were willing to pay. And so they would offer a lower rent in order to rent apartments. And for a time, if they offered that lower rent, when the lease was up for renewal, they could remove what was called the preferential rent and go back up to a higher rent. That was changed in 2019, in June 2019. If someone had a preferential rent before June 2019 and was offered a renewal, the landlord would have to continue the preferential rent for the duration of that tenancy, meaning they could increase it, but they would have to increase it at the lower amount in terms of what the tenant would be obligated to pay. Overcharges is a huge topic, and it's much too complex for us to be able to fully address it in this workshop. What I would like people to know is if you're in rent stabilized housing, you should always ask for a registration history from HCR. You can do that by calling HCR, the number that we have in the resources. You can also do that by asking for an appointment and going in person to HCR at 1 Fordham Plaza. And what those registration histories will show is who has been registered as a tenant and what increases have been charged. And if you do get that type of a statement, you'll want to review it with either a counselor at HCR or with a housing advocate or attorney to see if there's anything in that history that would lead you to believe that there might be an illegal increase. It's the kind of thing that's very hard to know for sure, even for attorneys, but there are certain things that are clues or signals that you should investigate or dig a little deeper to find out whether there's a possible overcharge. The other category of cases where there could be an overcharge are apartments that are not registered, where the landlord says the apartment is, quote, exempt. And that's something else that you'll want to get a rent history, get as much information as you possibly can from HCR, and review the information you get with a counselor at HCR or a housing advocate or attorney. There's a lot of overcharges. I don't know what to say about it. It's one of the more depressing aspects of our work that there was a law that was passed, the Housing Stability and Tenant Protection Act, and it greatly improved the tenants' abilities to assert overcharges. And then part of that statute was ruled to be unconstitutional at the beginning of the pandemic. And so some of the good changes were not permitted by the courts to take effect. So what can happen is there can be an illegal increase, and if it's not challenged within the time provided by the law, unless you can prove what's called actual fraud, the court may say that they won't disturb the overcharge. So it's very, very important to be connected with an attorney if you suspect an overcharge. I hope that generally answers the question. I'm gonna also, sorry, I'm just scrolling through the chat. So someone asked, are they back at 1 Fordham Plaza? Yes, they are. My understanding is they're there. Oh, is that
so Beth, are they back there? Because I know at one point they had moved over near Zarita.
I thought they were, and I guess I'm not 100% sure. I haven't been back there myself in person. So I guess I would call first and find out. Thank you. We have a couple other questions that I want to make sure we have time to touch on. So there's some questions about discrimination. If a tenant experiences discrimination and by the landlord and they're afraid to report it for fear of retaliation, what do we suggest be done? And a related question, let's say a tenant has a voucher to rent new housing and they encounter a landlord or a broker that refuses to accept the voucher, what should be done? And I just want to assure everyone that in New York City, we have an anti-discrimination law that is very, very strong, includes what we call source of income discrimination. And so if someone has a voucher and a landlord is refusing to accept it, that is illegal. And the City Commission on Human Rights is where we would recommend filing a complaint. HRA also has a unit that is tasked with trying to address discrimination for its vouchers. And so we'd recommend anyone who has an HRA voucher to contact 311 or contact HRA if they're experiencing a landlord not accepting that voucher. In terms of broader types of discrimination, I mean, retaliation is real. And I don't want to mislead anyone to think that they'll, that they wouldn't potentially encounter it. But I do want people to know their rights and not be afraid to exercise their rights, and retaliation is illegal. So again, I would encourage anyone who has questions about either whether to address or how to address discrimination to try to contact an attorney, if at all possible. Who are reliant on a voucher or a subsidy to pay rent, and there are times when those things are interrupted for reasons. It could be the tenant failed to do something, it could be the landlord failed to do something, it could be the agency made an error. Regardless of the reason, nobody should be harassed over payments that are needed. I want to be careful to use when I use the word harassment, there is a legal cause of action for harassment. So if someone is being harassed, there is an anti-harassment law, and tenants can file a complaint in housing court. It's a type of HP proceeding to address the harassment. But asking someone about rent that's not being paid is not necessarily harassment. That is something that's within the business of what a landlord would typically do. If it rises to the level that someone is feeling harassed, you can ask for the communication to stop, or you can refuse to engage in the communication. And you can consult with a lawyer or an advocate if you feel that's needed. Sometimes we encounter situations where a landlord may accept a tenant with a voucher and want them to pay what's called a side deal. So say they advertise an apartment, they say it's $1,500 a month. The person has a voucher for $1,500 a month, and they get there and they say, oh, you know what, we really want $2,000 for this apartment. And they tell the tenant to sign something to pay something on the side. That is completely illegal and should not happen. And that's also potentially a fraud on the agency that's providing the voucher. So we definitely would not want anyone to pay those illegal side deals if they have them, and to report it to a lawyer and to the agency if possible. The other question we had to do with increases in rent. We did touch on this with one of the previous questions. So in private housing, landlords can raise the rent or can seek to raise the rent large amounts. However, a lease is a contract, and tenants are not required to agree, and instead can try to negotiate. And if they can't come to an agreement, tenant does not have to pay that increase. They can choose to leave, or they can wait for the landlord to have the opportunity to bring an eviction proceeding. You don't have to agree to rent that you can't afford to pay. But I would recommend trying to negotiate to the extent that you can. And I see Jack put in the chat that he did confirm the address for HCR. Thank you, Jack, at 1 Fordham Plaza. Sorry, I know that was fast. I wanted to make sure I got to those questions. And I want to ask if we have other questions or comments. Genesee, do we have anything else in the chat?
No, I think we covered everything.
I see we have a couple more participants, so I want to ask Arturo if he wants to introduce himself. Arturo Urena.
Sure. Hello, my name is Arturo Ureña. I am the legal clinic supervisor. I was part of the Spanish version session that just ended a couple of minutes ago.
Okay, any questions from that session that you want to share with our group? I think we've just about finished the questions that people have shared with us.
Not really. So someone asked what would happen if a tenant does not want to sign the lease, and and whether the landlord could still allow you to stay in the apartment or not. Yeah.
I think we touched on that here. So sounds like we had a similar experience.
Just, we are right at the time we sort of thought we would be, 90 minutes. So I think it is a good time to say goodnight. And thanks to our friends at Kingsbridge Heights Community Center and the Bronx Bar Association. And yeah, have a good night, everyone.
Thank you, everyone, for joining us.
Thank you for coming. Hope to see you all in the future at another one.
Thank you all.
Thank you so much for the information.
Good night.
Thank you.